Welcome to the She Said Privacy, He Said Security podcast. Like any good marriage, we will debate, evaluate, and sometimes quarrel about how privacy and security impact business in the 21st century.
Hi, Jody Daniels here. I'm the founder and CEO of Red Clover Advisors, a certified women's privacy consultancy. I'm a privacy consultant and certified informational privacy professional providing practical privacy advice to overwhelmed companies.
Hi, I'm Justin Daniels. I am a shareholder and corporate M&A and tech transaction lawyer at the law firm Baker Donaldson, advising companies in the deployment and scaling of technology. Since data is critical to every transaction, I help clients make informed business decisions while managing data privacy and cybersecurity risk, and when needed, I lead the legal cyber data breach response brigade.
This episode is brought to you by... Hello, that's where you ding.
Beep.
Red Clover Advisors. We help companies to comply with data privacy laws and establish customer trust so that they can grow and nurture integrity. We work with companies in a variety of fields, including technology, e-commerce, professional services, and digital media. In short, we use data privacy to transform the way companies do business. Together, we're creating a future where there's greater trust between companies and consumers. To learn more and to check out our best-selling book, Data Reimagined, Building Trust One Bite at a Time, visit redcloveradvisors.com. Well, hello.
What's up? Been a long time since we last broadcast.
Well, we're here for some more fun. Are you ready for some fun?
Let's have some fun.
All right. Today we have Jessica Lee, who chairs Loeb and Loeb's Privacy, Security, and Data Innovations practice and serves as Chief Privacy and Security Partner. Jessica provides strategic legal counsel to companies navigating complex data governance issues, helping companies turn compliance into a competitive advantage, which I just love. So Jessica, welcome to the show.
Thank you for having me.
You're back to being giddy again today. Did you take like the giddy pill or something?
No, I did not. I had coffee this morning, but I don't drink coffee.
Maybe you should try some.
No, they have lemonade, so I drink that.
I had a delicious cup of coffee this morning. It was so hot. And I'm trying to figure out how they keep it so hot. My coffee at home is hot for about 4 seconds.
One of the world's mysteries.
It is a mystery. If anyone listening has a solution to keeping my coffee hot, I genuinely would like to know.
Maybe you should make that into a LinkedIn post with a hot cup of coffee.
It's a good idea. I need a social post today. It's going to be coffee. If anyone's listening, now you know when we record it. Okay, carry on.
I'll say, I can give a suggestion here.
Oh, please.
You need a mug, and Zojirushi is a Japanese brand. It is the best coffee mug I've ever had. I make the coffee at home like 4:00 if I wanted to. Coffee is still hot later in the day.
Ooh, I definitely need to check this out. Thank you. I really appreciate it.
That is my contribution.
I appreciate it. All right, we're all done here. We can move on. Okay, no, we're not really going to move on. Your turn.
Okay. So, Jessica, why don't you tell us a little bit about your career journey?
Sure. Well, my journey is probably similar to some of the other privacy professionals you've spoken to, in that it was winding. So I, started my legal career off at Skadden Arps in their litigation department. So I was doing like securities litigation, completely unrelated to what I'm doing today, except the fact that, generally litigation skills I think are very transferable, but there was no privacy curriculum when I was in law school. I think the closest I got was an electronic communications class and some media and communications classes, but it wasn't an area that was introduced to me. And so I, stayed at Skadden for a few years. I had a federal clerkship for a year, and then I made my way over to Loeb and Loeb in 2011, mostly because I thought where my interests were going to lie were really at intellectual property. And Loeb had a great practice, great entertainment practice, big advertising practice. But while I was here, I started doing work for a group called Advanced Media and Technology. And that work was really exciting. That was where kind of all the digital work landed. It was a group that the firm formed when Google acquired DoubleClick, with an eye that they would deal with all of the issues that would come up when advertising went online. And so they had some privacy issues, and when they needed help, I would do the research. And a year into my time at Loeb, I moved into that group full time and started doing all the things that group did, but eventually focusing on privacy. And then, now I'm the chair of the group.
I love the winding concept. It really is true. So many privacy professionals, if you're not brand new at kind of graduate who's choosing this career, but if you've been doing something for a while, there's definitely a winding path. I really like that concept.
Which I actually think is good because I think you get the grounding in the business and the industry and other legal principles, and all of that is relevant, I think, to what we have to navigate on a day-to-day basis. And so I do think it's helpful, even though sometimes I'm jealous of the people who say they can come out and they know exactly where they're going and they've taken, a ton of privacy classes in law school and they just kind of hit the ground running.
I do agree. I think the business experience that I have is really helpful because I'm always thinking about the business issues from multiple different angles because of the experience I have when we're trying to sort through whatever interesting problem they have. Speaking of problems, today we're going to talk a lot about CIPA, which seems to be the bane of some privacy pros daily. And it's a really popular discussion. And at the same time, not everyone actually knows what CIPA is. I was hoping we could start with, can you give us a little bit of a primer? What is CIPA? And then do we just have to worry about CIPA, or are there CIPA-like other laws that maybe companies should be paying attention to as well?
Yeah, absolutely. So, I mean, at the federal level, there's a Federal Wiretapping Act. And then there's ECPA, the Electronic Communications Protection Act, which extended the federal wiretapping regulations to electronic communications. And so CIPA, California's Invasion of Privacy Act, is the state law version of that federal bill, right? So we see this in a number of places. You have a federal law, you have state law versions or implementations of that. So that's to say that CIPA is, I think, one of the most popular with the plaintiffs bar. But there are CIPA-like laws in multiple other states. And, the plaintiffs bar, I think, has latched on to CIPA in part because for eavesdropping at the federal level and then at some states, you only need one party to consent, right? So if I'm the one recording our call and I consent, that's good enough. California requires two parties to consent. And so that's where the rub is, right? If you don't have the other party, meaning the consumer in most cases, their consent, you potentially have an argument that you violated CIPA. And so big picture, CIPA is the state version of the Federal Wiretapping Act, which makes it illegal to record calls or intercept communications, I should say, without the consent of both parties. And there's some nuance in there. It's a content of the communication. Those communications have to be in transit. But big picture, that's what the regulation covers. And there's the interception of communications piece of it. There's also another piece of it, which has become more popular, I would say, like in the last year or so, which also restricts the use of pen registers and tap and trace technology without getting a federal subpoena or without getting a subpoena or without getting consent. So we see interception of communications or using tap and trace technology. Those are kind of the two prongs of CIPA, and those are where most of the claims have been concentrated.
Very good primer. Thank you so much.
So I think the next thing we're interested in talking a little bit about is, can you give a flavor for what we're seeing lately with some of these CIPA cases and how they're progressing through the courts? And do you see them increasing or decreasing? I would think with AI, we may only see more stuff. But what do you think, Jessica?
Sure. I mean, it's like a little bit of a roller coaster that's actually been going on for several years at this point. So we started off a few years ago with claims that session replay cookies, right? Cookies that would be on the site that would basically monitor your mouse movements or create heat maps. The idea was for the most part, the session replay cookies were used to understand how someone was navigating around a site so you can make sure it's optimized for the best use. Sometimes the session replay cookies could be used to capture consent. So if you're getting consent, that cookie could be used for that purpose as well. But I think, prior to that had been seen as fairly innocuous cookies. But the allegation was that because you could capture some potential communication with the website, that the use of those cookies without getting consent violated CIPA. And there have been a mix of decisions. There were a number of favorable decisions to the defense side, which came out and said, well, this isn't really what this technology isn't really what the law was meant to cover. These aren't really communications. Questions around whether or not it was in transit, kind of getting down into the weeds of what these claims were. And then, the plaintiff's bar that was very creative. And so they just move on, right? And so we've seen these cases brought up in the context of a session replay cookies. We've seen it brought up in the context of chatbots. I think those have had a little bit more stickiness, although that's an easier problem to solve. You put the fact that the chat will be recorded at the top of the chatbot window, and that should be sufficient. And then you see in a new flavor, which was really focused on social media pixels with, Meta and TikTok pixels being kind of two, I think, of the, again, favorites of the plaintiff's bar to say using those on your site without getting consent potentially violates CIPA. And so those have wound through the court. The problem is there have been a number of cases, like I said, that have came out and said, this doesn't apply or have dismissed the claims for a variety of reasons. But you always have one or two cases here and there that give the plaintiff's bar some hope. And so that's kind of what we've seen. And the most recent wave that I mentioned earlier with the tap and trace technology. And, just to, for those who haven't dug into this, the pen register and the tap and trace, think of it as like outbound and inbound, right? So one records address information that gets sent out. Others record what gets sent in. So it's not the content of the communication. It's basically like the addressing information, the sender and the receiver information. So if we're talking about pixels, we're talking about like IP address, for example. We have seen some favorable cases. There was a case actually involving Kachava that alleged that session replay software could be a pen register that was installed without getting consent. And the court there said, well, if the software identifies the consumer, gets data, and correlates that data through fingerprinting, that potentially could fall into the definition of a pen register under CIPA. And so again, that gives the plaintiff's bar some hope. And we should keep in mind here, I don't know how many plaintiff's lawyers are listening to the podcast, so I will apologize in advance. But, from my point of view, these are really shakedown claims, right? Like we have cases that are working their way through court, but the vast number of these are getting settled beforehand, right? Because litigation is expensive and you really have to have the appetite to fight the claim. So a lot of these, you're getting like form letters that get sent that say, we can see that you have this cookie, this chatbot, we have this pixel installed on your site. You did not get consent. You violated CIPA. Sometimes they'll tack on some other claims. And, sometimes these things settle from somewhere between like $12,000 and $50,000. Rinse and repeat that, enough times. That's a good enough business, I guess, for some. And so we're watching what happens in the court, but we're also just seeing a lot of these cases get settled. And when you have one or two good decisions, it just means that the life of these will continue. And if you get a bad decision, you'll just find a new avenue potentially or a new creative path through which to kind of push these claims forward. So I do think that, if you asked me this question maybe like a year and a half ago, I might have said, oh, we've got like a couple of favorable cases, so we might start to see these die off. But with, some of the cases that came out last year, I think there is at least a sprinkle of hope for the plaintiff's bar. And so we'll see them continue, at least for now.
As my next question is, what do we think about the flavor for the next wave? So I guess we'll just have to wait and see a little bit, which brings people listening. Well, the $1 million question, well, maybe not $1 million, just the big question. What should companies do to try and help mitigate the risk from any of these cases? What would you recommend companies start with?
Sure. I mean, I would start with doing an audit, right, of your site, right? Because these are the reason why these claims are somewhat easy to bring because it's visible, right? You can use easily accessible technology to scan a website and see what cookies are running. You can look into the code or the header of the site and see potentially what data is leaving and who it's going to. And that's really what's forming the basis of these, the demand letters when they come in. So, and a lot of companies, particularly larger companies, if you have multiple websites, multiple platforms, multiple teams running these platforms, getting a good system of understanding, well, what's actually on all of the sites that we control and how is everything configured? Do we need to, make it clearer in our privacy policy that we're using this technology? Do we need to get consent? Consent not necessarily always being opt-in consent, but is there some version of consent that we need to get that would, make our position a little bit more defensible? What can we put in place? If we have a chatbot, do we have, the consent language in the chatbot? So, the base layer of everything is figuring out what's going on your site. And then the next piece of it is, do we have things configured properly if we're not trying to share as much information? And if we don't, do we need to be clear, transparent, and look for ways to get consent? Those are kind of the steps I would take.
Well, knowledge is certainly power, and always understanding which pixels and which cookies you have on a site is very, very important. And we see a massive gap of companies not knowing what is there for a number of different reasons that I think we might talk about here soon.
Yeah. And I would also say, there's a concept of a primary purpose exemption or primary purpose exemption. So if a company is working on your behalf, like they're an extension of you, they're not using your the data for their own purposes, that potentially is an avenue out of these of this litigation. But that requires you to have, good contract terms in place. So after you get past the technology piece, it's also what terms do we have in place? Do we have strict controls over, any third parties who have cookies or trackers on our site? If we can't get those terms in place, can we configure it so that they don't get as much data, or the data gets sent back to our systems, not to their systems? So it's hard to give, the high level advice because you kind of have to get into the weeds of what's going on your site. But it's both the technology, I think, and also some of the contractual protections, again, trying to build up as many defenses as possible for when these claims come.
Jessica, is that suggesting kind of like the service provider concept, where if I was sending data to this other third party, but the third party can't use it for other purposes? Is that what you mean, or something a little bit different?
Yes, exactly. And that's for the interception of communications prong of CIPA. So if you can show that third party is merely acting on your behalf, right? They're not using that data for their own purposes. That's one potential avenue out of the lawsuit. And I should say the challenge here is also and we see this in other cases. This comes up in the VPPA litigation as well, where you're applying old laws to new technology, and so you're seeing judges kind of grapple with, does this thing that didn't exist when this law was passed, does it kind of fit into this legal framework? Like, can we parse through this technology and how it works? And you're asking judges to parse through technology and understand how it works. And sometimes that works well, and sometimes it doesn't. I think that's also why you're seeing this like back and forth in some of the case law, because it really kind of depends on who you're in front of and how well you can explain whether or not what you did on your site meets the statutory definitions. So that's also why it's kind of like, building up ammunition. So it can't be just one. There's no like one solution. It's not like slap a cookie banner up on your website and that's going to take care of it. You need to have multiple potential defenses against these claims.
The idea of a archaic law and modern technology, Justin, I feel like we've had that discussion a number of different times in a variety of areas.
Yep, the VPPA would be another one. And I'm trying to think, but you're right.
Well, just even in general. So beyond banners and opt-outs, so we just talked about maybe not just a cookie banner is going to be the complete solution. What are best practices that you're seeing companies do as it relates to managing all these different pixels and trackers that they have on their sites?
Yeah, I mean, that cookie audit and cookie management and having a program around that, it's not always possible, but, companies that are able to have either a centralized system so that, there's one place to manage when cookies go up and come down, particularly for companies that, run ads on their site. Sometimes cookies go up in a campaign and you don't remember to take it down. So you have a cookie that's on the site that, no one's remembered to remove, right? So getting good kind of cookie pixel hygiene, I think is critical. If you can't have it centralized, have clear owners, right? And have some system or process in place so that you don't have activity happening on your site that could jeopardize your position. Because what I see sometimes is that, legal or whoever's in compliance puts together a privacy statement or they design whatever the privacy communication or disclosure is on the website. And then you have another team that's actually doing the things that the website does, right? Like the advertising, the marketing, promotions, all the coding. And if those two teams aren't talking to each other on a fairly regular basis, what I told you today that went into what those disclosures said might have changed. And so now what you said publicly is no longer accurate. And so making sure that there's this kind of like constant flow of communication, I think is critical. I mean, and I do see companies putting up, cookie banners or looking for more prominent notice, making sure whatever they're doing, whether it's session replay cookies or something else, all of that is clear in their privacy policies. I mean, this litigation is all happening at the same time as we're seeing, each year a new wave of new privacy litigation privacy regulation from the states that also requires you to, have transparent notices, sometimes get consent, provide clear opt-outs. I think it's challenging for companies because you have one set of regulations that says one thing, and most of these laws outside of sensitive information or kids are opt-out, right? You can have the do not sell or share in the footer of your site, and that's general that complies with most of what these regulations require. And then you have this litigation that's coming up, and you're trying to play whack-a-mole with it, and so do I now need to get opt-in consent when the law doesn't require me to get opt-in consent? Do I get opt-in consent because that'll satisfy this risk, knowing that there's some new law that could get dug up, right? We saw, maybe it was last year, the year before, a New Jersey law, the Daniels law, was being brought out potentially. So there's always going to be some attempt to, raise some law from the dead and use it for a new purpose. And I think kind of trying to anticipate that is a challenge. So I see companies just trying to get good hygiene around what they're doing so that they can make sure that they are at least as buttoned up as possible, understanding that it's like trying to chase a ball down a hill, like trying to get ahead of the litigation. So I don't know if that's the best endeavor as opposed to just making sure you have a defensible position about what you've done in terms of your program.
Cookie governance, I think, is a popular topic this year that I'm really hearing companies focus on. And the need to be able to understand and really rein in what is actually happening on the site. A lot of companies will rely on agencies, and agencies sometimes have free rein, and companies don't always know what is actually happening. So I would encourage anyone listening, if you're working with agencies and they have access to your site, to really create ongoing reviews, ongoing scans, conversation, approvals in place to be able to manage that. And some people might say, well, but there's thousands of those pixels. There's still a way to be able, there's our tools and technologies available to be able to scan for that. And then you need someone to be able to review and kind of flag. And I also see, Jessica, what you commented on, which is that people will put those pixels up and then they forget to take them down. And you could have those up for years. And when you do that scan, people are saying, what is that random cookie? Oh, right. Remember, we tried those people out and we completely forgot about them. For years, you've been giving data now to a company, and who knows what that company is doing with that data. So we really don't want data leakage, and cookies are one of those places that can have that. And I'm very excited that I think cookie governance is here to stay or get started, even more than just cookie banners. I think we're starting to move to that next evolution beyond just the banner and opt-out or link.
I hope so. Yeah, because I see the same thing. And I feel like we've had conversations, coming out of the EU and the e-privacy directive to all of the cell share conversations, there's been a lot of talk about cookie and cookie governance. But, these are big lifts for some companies. So I feel like it's been a slow move, but I definitely see the momentum increasing because the risk, you just can't ignore it now. Now it's kind of coming from all sides. So it's hard to bury your head in the sand, even though it is a big project, I think, to get your arms around.
Absolutely. I completely agree.
So, Jessica, what is your best personal privacy tip you'd share if you were hanging out at a party and privacy came up?
Well, it comes up at every party I go to. So, I really have to sample my toes with information for people. I'll say two things. It kind of depends on who I'm talking to and where they sit. So for example, my sister, unlike me, is very much a tinfoil hat person. She, does not want to be on social media, does not want any of those things. And so, I tell her where to go to look in the privacy policy for the information that she wants, right? Like you want to know what's getting collected and who it's going to, and generally how it's going to be used. And so how do you kind of parse through what ends up being a long document to find kind of the key information? And then, I talked to her about things like the controls on your browser in terms of like clearing your cookies out, making sure all the heightened controls are on your phone. Not everyone is in that position though. So if I'm talking to someone who's a little bit, just call it a little bit more open about things, I go back to just at least understand what's happening on the site when you're navigating it. Look at the privacy policy. That's what it's there for. And then make a decision based off of that.
Good advice. I read privacy policies.
Yeah. You don't have to read the whole, you should read what you like. You don't have to read the whole thing. I feel like there are key
relevant sections.
Yeah, exactly. Relevant sections for, I didn't know that they were doing that. Well, they told you, you just didn't want to read, the policy for it. But yeah, and obviously there are tons of controls with people who don't want to be tracked and don't want to be followed and, browsers that people can use. But most of the time, at all the fun parties where privacy is the hot topic, people really just want to understand why or how something's happening, as opposed to all like wanting to shut it off. It's more of a, how do I figure out what's going on and parse through the noise?
Interesting. So when you are not advising clients on privacy or talking privacy at a party, what do you like to do for fun?
Well, anyone who's heard me speak before, this might not be a surprise and might not be that fun to everyone, but I run marathons. So that is a hobby I guess I have. I was up at 6:15 on the track this morning in the freezing cold to run to prepare for the next marathon that I have. So I don't know if that qualifies as fun, but that is
it's fun for you.
That is something I do for fun.
I am glad there are people like you who find that fun. I do not find marathons fun, but that is okay.
Yeah. Well, you travel. I'm running the Berlin Marathon later this year. So, you go for a couple of hours of running in Berlin. That can't be bad.
Oh, the Berlin part sounded good.
Yeah.
That it was the couple hours in the middle.
Yeah.
I see. Well, Jessica, we're so glad you joined us today. If people would like to connect and learn more, where's the best place to go?
Sure. You can find me on LinkedIn, or you can, actually LinkedIn is the best place. So if you look for Jessica B. Lee on LinkedIn.
Awesome. Well, thank you so much. We really appreciate all the insights you shared on the fun of CIPA. Thank you.
Thanks for having me.
Thanks for listening to the She Said Privacy, He Said Security podcast. If you haven't already, be sure to click subscribe to get future episodes and check us out on LinkedIn. See you next time.